This conference is now being recorded.
Good afternoon. Welcome to the New York State ASBO webinar, School Elections 101, in conjunction with the New York State School Boards Association. My name is Matthew Darius. I'll be moderating today's call. Your presenter today is Kim Faniff, Associate Counsel with NYSSBA. If you have a question for Kim at any time during the webinar, you have two options. You can use the chat pane located to the right of your screen, or if you'd like to ask a question over the phone, you can hit the number 7 and the pound key. That'll notify me you have a question. I will then unmute you, and you'll be able to talk. With that out of the way, Kim, it's all you.
Good afternoon, everyone. Hope you are doing well. The New York State School Boards Association is very happy to be partnering with our sister organization, New York State Association of School Business Officials, on this series of webinars. And today, yes, I'm going to be talking to you guys about School Elections 101. Obviously, as school business officials, all of you are intimately familiar with budget preparation. So the goal today is to give you a broader sense of the responsibilities the school district has in running the annual election and budget vote. So we're going to be covering a lot of ground today. In general, the topics are going to range from activities preceding the vote, the notices and other information that has to be sent out, voter propositions, voting at elections, including by absentee ballot, canvassing and announcing the results of the elections, improper advocacy issues that school districts face, going over the elections of school board members, and finally, challenges to elections that can sometimes occur. So we'll start off with, of course, the annual meeting and election, which, as probably the date is burned into all of your brains, that is the third Tuesday in May. It may be changed if you have a need to, because of a conflict with a religious observance. You can submit a request to the Commissioner of Education no later than March 1st based upon this conflict. School districts have done this in the past couple of years because there has been a conflict in a district that had a very large Jewish population with a Jewish holiday, and the Commissioner did in fact grant them that ability to move the election. Some elections for board members in the Big 5 school districts do take place at different dates and times specified by law, but those are the only times that the elections for school board members are separate from the budget vote. Voting on budgets and elections of board members on separate days is not permitted unless it is in fact authorized by law. So voting on the school budget, you have to keep your polls open for a specified number of hours. In most school districts, it's at least 6 consecutive hours after 6 a.m. 2 hours of that time must be after 6 p.m., and it's set by school board resolution. In small city school districts, they have to keep the polls open for at least 9 consecutive hours, beginning no later than 7 a.m., and 2 hours of which have to be after 6 p.m., again, set by a board resolution. The places for the election. The election is held at the schools designated for this purpose. If, for some reason, a school and there is not a school building or it's not accessible or adequate, then an election can be held at any place within the district suitable for the occasion. It is the school board that designates the location if it's going to be in something other than a school building. I got a call actually earlier this week from someone on the legislative staff for a senator from the western part of the state where a city council in a small city school district was attempting to interfere with the location of a polling place for a school district election. So these are questions that do in fact come up from time to time. Opening the polls. In common school districts, the election is called to order either by the sole trustee, if they have only one trustee, or the chairperson of the board. And thereafter, the voters elect a qualified voter to serve as chairperson of the election. This is so because common school districts are still authorized to hold a meeting of district residents and vote by a showing of hands. Most, of course, no longer do this as it's not practicable, and they do conduct the election with voting machines or paper ballots. But they do have that ability. In free school districts, central and small city districts, the board appoints a qualified voter as chairperson who declares the polls open and closed. Activities that precede the annual meeting and election. Some of these you guys are going to be pretty familiar with, such as preparation of the property tax report card and the budget notice. But the notice of annual meeting is really the biggest one. We have to make sure that the notice is published 4 times in the 7 weeks preceding the election in 2 newspapers of general circulation. And the first publication has to be at least 45 days prior to the election. So the question you may be having is, well, what the heck constitutes a newspaper of general circulation? That's a newspaper that's published at least weekly and has a paid circulation. So sometimes I get calls from district clerks asking, well, can we use the penny saver? And I say the penny saver, if it has a paid subscription, sure, but if it doesn't count as a newspaper of general circulation. The fees that are charged are governed by law. It is very expensive, and I know districts always have a concern about that. The contents and publication is dictated by the law, as I said, and we're going to review on the next few slides what that content is. We want to make sure that the district gets it right in their notice of annual meeting so that they don't face some sort of challenge from the public for giving inadequate notice, and that's an easy way to make sure you are not facing a lawsuit challenging your election for something that's completely within your control. If there is no newspaper of general circulation or the newspaper of general circulation refuses to publish your notice, then the law allows you to post notice of the annual meeting in at least 20 of the most public places, again, 45 days before the meeting. So the contents of this notice, we have to include the date, time, and place of the annual meeting, pretty basic there, the date, time, and place of your budget hearing, and information about when and where to obtain copies of the budget during the 14 days preceding the budget vote and on the day of the vote. Copies of the budget have to be made available at any district schoolhouse during designated hours on each day other than a Saturday, Sunday, or holiday under the law. So we need to inform them about when that is available. Next, the notice has to include notice of any proposed tax, together with a statement specifying both the purpose and the amount of spending for which the tax will be levied, and where such tax is proposed to finance items specified in law. So proposed taxes that are specified in law, things that we have to include there would be an addition to or change of site or purchase of a new site for a school building, grading or improvement of a school site, purchase of an addition to the site of any schoolhouse, purchase of lands and buildings for agricultural, athletic, playground, or social center purposes if the district is going that route, construction of any new schoolhouse or the erection of an addition to any schoolhouse that's already been built, and payment or refund of any outstanding bonded indebtedness. All of those very specifically have to be laid out in the notice of annual meeting. Also, where required by law, the substance of specific propositions that are going to be voted on needs to be included in this notice. So propositions that have to be included in the notice would be to levy a tax by installments as a precondition for a bond resolution, to rescind a district vote to raise money or to reduce the amount thereof, to establish certain reserve funds. You guys well know those are very explicitly governed by provisions of either the education law or the general municipal law, and to increase or decrease the number of members of the school board would need to be in the notice of annual meeting, and to increase or decrease the term of office of a school board member in small city school districts does in fact need to be included within the notice of annual meeting. So we also have to have in there a statement about applying for absentee ballots, and that a list of persons who have been issued such ballots will be available for inspection at the clerk's office each of the 5 days before the election, excluding Sunday. This is so that to facilitate challenges to those who have been issued absentee ballots if a voter would so choose to do so, and we'll go over that in a little bit. And the time and place the Board of Registration will meet, and notice that the register will be available for inspection. This is only applicable if you have a system of personal registration within your district. If you do not have a system of personal registration, then this obviously would not be applicable. The due date for filing of nominating petitions needs to be in that notice, and so it's between 9 and 5 p.m., no later than 30 days before the election. However, in small city school districts, it's in 20 days before the election when those petitions are due. If a deadline falls on a Saturday, Sunday, or holiday, the general construction law tells us that the filing may be performed on the next succeeding business day. Just a little extra information for you there. So the public hearing on the budget. This has to be held at least 7 days, but not more than 14 days prior to the annual meeting and election, or a special district meeting at which a school budget vote will occur. Large city school districts are not required to hold a public hearing on their proposed school budget. This is because they're fiscally dependent and the voters do not approve the budget that's submitted to the city council or city controller, depending upon how things are set up by the city charter. The purpose of the hearing is to present to the voters the proposed school budget for the upcoming school year. So many of you know, in fact, that you may be involved in participating in the public hearing on the budget. The notice, again, time and place does have to be included in the notice of annual meeting, and the notice, a quorum of the board is not required in order to hold a budget hearing. Districts do make a budget hearing part of a regular board meeting. Thus, there would be a quorum of board members present, but it's not necessary. A lot of school districts do have it as part of that, but even it's not the board that makes the presentation. It's either the school superintendent or the school business official, or sometimes them working in cooperation. The public does not have any right to delete items from the budget at either this stage or at the polls. This is just to inform them of what has been included within the budget. Some districts do engage in community forums beforehand, before the proposed budget is adopted by the district, to understand what priorities the public has for the school district, and certainly that is allowable, but that is not the public hearing on the budget. So the budget notice, following the public hearing, you have to send out the budget notice. It has to be mailed to all qualified voters in the district no later than 6 days prior to the annual meeting and election, or a special district meeting if you have to have a budget revote. The content notice has been amended by the property tax cap law to include information regarding the school district's property tax levy limit. In addition to that, you guys are probably pretty familiar, the budget notice has to be in a format prescribed by the State Education Department and include specific information that's required under the education law. For example, it has to include information about the comparison of total spending between the proposed budget and the budget for the current school year, information about estimated tax savings under the Basic STAR program, and format is available from the State Education Department. They included the amended format in the guidance document on the property tax cap legislation. So if you haven't seen a copy of it, it should be available within that document. Voter proposition. Districts that use voting machines have to have a policy on the submission of propositions. So the policy is adopted by the Board of Education, and the board has a lot of flexibility in adopting this policy. They can specify a minimum number of signatures that is required in order to have a proposition to be considered for the ballot. The voters are not required, however, to list their address when they sign these propositions, petitions for these voter propositions. The Commissioner of Education has said that the statute does not require voters to list their address. So the policy is going to be limited to reasonable rules about format, numbers of signatures, and deadlines for submission. These rules for placing voter propositions on the ballot are not applicable to propositions that are put up by the Board of Education itself. These are only ones that are generated, applicable to ones that are generated by members of the community. Generally speaking, voter propositions have to be filed at least 30 days in advance of the election, unless required by law to be included in the notice of annual meeting. So the board has the ability to set a reasonable deadline for submission of these propositions relating to topics that are required to be included in the notice of annual meeting, that is, in advance of this 30-day deadline. So the Commissioner has upheld as reasonable policies requiring submission to the board 90 and 60 days in advance of the annual meeting when the topic relates to one of those that has to be in the notice. Propositions which must be included in the notice of annual meeting, again, that to levy a tax by installments as a condition of adopting a bond resolution, to rescind a district vote to raise money, to establish or spend money out of the reserve funds, and the propositions relating to increasing or decreasing the number of board members or the term of office in small cities. Acceptance of voter propositions. So the Board of Education is going to determine if the proposition submitted by the voters conforms with its policy in order to be placed on the ballot. Once an issue has been placed before the voters in a particular year, the board may refuse to place the issue on the ballot again in the same year. So if you have something that has been placed on the ballot when you have the original budget vote and your budget goes down, you would not necessarily have to put the same proposition up if you chose to go to a revote on your budget. An exception does exist to this, of course, because isn't there seemingly an exception to every rule? If an issue has been previously placed on the ballot, is that the proposition seeks to abolish any library that was established by public vote at a previous district meeting. So you could have a proposition that goes up to establish a public library, and you may be required to place a proposition on the ballot to end that public library at the very next meeting. We have the ability to reject propositions that are not within the powers of the voters. So some examples of voter-submitted propositions that have not been accepted: asking the voters to set aside $200,000 of district money to fund a lawsuit against school officials. You're not required to put that up before the public. Requiring the board to submit the budget to the voters more than once prior to adopting a contingency budget. The board has discretion to determine whether or not it will go to a revote, and you cannot be forced by the voters to always have to submit two budgets to the public. Require proposition that sought to require the board to schedule a vote on an alternative budget devised by a citizens group. That was not required to be put up because the authority to develop the budget rests with the board, not with the public. And additionally, the Commissioner said you could reject the proposition that sought to curtail the authority of the board to contract with other districts for education of students. So district voters typically approve contracts, but only the school board can designate the receiving districts if you're going to be tuitioning out your students to another school district. We can reject a voter proposition if it requires an expenditure of money but fails to specify the amount of the money. Additionally, we don't have to place two conflicting propositions before the voters. So two conflicting propositions, an example would be one that has been submitted for construction and another for renovation of the same building. We're not going to place on the ballot two confusing options for the voters, such that it would be difficult for us as a district to discern what the will of the voters actually was. The board does have the ability to alter language of propositions, so we can make minor modifications to two otherwise mutually inconsistent propositions such that the voters have a clear choice between the two options, and there's nothing improper about doing that and submitting those propositions to the voters at large. But we are not required to do so. So we don't have to alter the language. That's just an option that exists for us. Lastly, the Commissioner of Education has said in repeated opinions that a board should not place matters on the ballot that do not require voter approval. While it's not illegal, advisory votes are not a good idea because it implies voter determination of the issue that's been submitted for consideration. And you could find yourself in a situation where your school district is now has decided to go the opposite way than what the voters expressed their opinion to be, and you're going to find yourself in a public relations nightmare. So the commissioner said the best thing to do is to avoid that altogether by not putting up advisory propositions. Lastly, any proposition submitted by the voters that will require an expenditure of money that would result in the tax levy limit being exceeded, then the proposition does have to be approved by 60% of the voters unless the proposition falls within an exception to the tax levy limit. We'll cover more about the types of propositions that fall under the tax levy cap, and those which are excluded when we review the material on voter approval of the school budget in just a bit. So voting at district elections. Who's a qualified voter? A person who's age 18, is a U.S. citizen, has been a resident of the school district for at least 30 days, and is not otherwise prohibited from voting. For example, they're not mentally incompetent or a convicted felon. Convicted felon only has the right to vote if they have been pardoned, their maximum prison sentence has expired, or they've been discharged from parole. Owning a home in a district does not make an owner a resident. The home has to be the permanent resident. I'm sure some of your districts are familiar with summer houses and people who attempt to vote on your school budget because they do own a second home in your district, but that does not entitle them to vote. They have to be permanent residents of the district. The district does have the ability to sue unqualified voters for a fine. It's a little outdated because the fine's only $10. So if you choose to do so, the court fees would probably cost more than the fine you'd be able to levy against them. However, any person who willfully makes a false statement about qualifications to vote may be guilty of a misdemeanor, and they could be subject to a fine by the court of up to $1,000 or imprisonment for 1 year. Voter registration. School districts, union-free, small city school districts, the school boards, have the ability to implement a personal registration. They can adopt a resolution for the system of personal registration and notify the Board of Elections within 5 days. Then thereafter, they're required to notify the Board of Elections 45 days before the annual election, and at least 14 days before any special election. Qualified voters not registered with the district who are registered with the county will be eligible to vote. The Board of Elections provides a list of registered voters to the district at least 30 days prior to the election when you adopt a system of personal registration, and then they provide a supplemental list of new registrants typically 10 days prior to the election. In small cities, the Board of Registration can require the Board of Elections to furnish registers on or before March 1st. Those can be duplicate copies the law provides, and this may be used to verify signatures of voters when they sign the poll list at the polls, and the register has to be returned the day after the election. So they could also choose to send these certified registry lists in place of the original registers. If they do so, then the board may require the voter to offer proof of identity pursuant to reasonable rules and regulations adopted no later than 10 days before the election. That is so because then you don't have the signature as a basis for a comparison. Voter registration lists have to be filed with the district clerk at least 5 days before the election and must be open to public inspection during reasonable times and days of the week, except Sunday, up to and including the day of the election. There is an exception. There is no requirement that the list be made available on the day of election in small city school districts. The place and time of registration is set by a school board resolution. The last day for registration is no more than 14 days or less than 5 days before the election. In small cities, the last day of registration cannot be less than 2 weeks prior to the election. Registration must be open for at least 4 consecutive hours between 7 a.m. and 8 p.m. Registration must also be conducted during the annual meeting for those who wish to vote the following year. It is improper to allow anyone who registers with the district on the election to vote in that day's election. However, if the person is registered with the county, they would then be allowed to vote. So someone could go and register with the county board of elections, show their proof of registration to you at the district, and then you would need to allow the person to vote. So voters can be given the option to approve registration occurring during the same hours that children may be enrolled in school or specified hours of the Office of District Clerk. This is typically, I think, how many school districts operate nowadays, that they have continuous registration available. You may request proof of residency prior to the election to maintain a voter's name on the list. We had a case from a few years ago, appeal of Taylor, where a petitioner was removed from the list of registered voters after the Board of Registration conducted an investigation into his residency based upon a challenge that had been filed at the prior budget vote. The Taylor showed up to vote in person at that prior vote and was challenged by the Assistant Superintendent of the district, and he was allowed to vote after he made the declaration that he said he was in fact a resident of the district and entitled to vote. And the Board of Registration, based on this challenge, conducted further investigation and determined, in fact, that Mr. Taylor was not qualified to vote because it was not, the home in the district was not his permanent residence, and they removed his name from the list of registrants. The commissioner said that the proof submitted by the petitioner of his residency in the Taylor case was not enough. He was, in fact, employed as a sheriff in New Jersey, several hundred miles away from the school district, and failed to submit any kind of New York income tax return to prove he was a resident of New York State. And he argued, Mr. Taylor argued, that a tax return, furnishing a tax return, would be an invasion of his privacy, but the Commissioner of Education said, hey, you simply have to redact the information and only show your permanent address that you list on your tax return, and that would be sufficient. So this is a way that school districts can clean up their rolls if they believe that there have been people who are voting who are, in fact, not residents of the district. The voter registration list has to include the name of everyone registered to vote at the meeting and anyone who has registered and voted in the district elections in the preceding 4 years. The Board of Registration or the district clerk, if you have continuous registration, is going to remove those who have died, moved out of district, or otherwise become ineligible to vote. The registration list has to include the name and street address of the voter, and it is, in fact, arranged in alphabetical order. If the district has a Board of Registration, 4 qualified voters sit on that. They're appointed annually by the Board of Education. They must be appointed within 30 days of the annual meeting and election, and they serve until 30 days following the annual meeting and election the following year. They are entitled to compensation at a rate set by the Board of Education, and a system of personal registration may be discontinued by board resolution. The resolution to discontinue personal registration has to be at least 2 months prior to the election so that there is proper time to deal with this. And thereafter, personal registration can only be reinstituted with voter approval. So, voter challenges. Any qualified voter has the right to challenge the qualifications of another voter when they appear at the polls. These challenges have to be lodged no later than the voter goes to the polls, because obviously you can't challenge someone after they've already voted. And the voter will be allowed to vote if he or she signs a declaration that they have been a resident for the past 30 days. In small city school districts, the chairman of the election is required to administer the oath to the challenged voter who swears that he or she has been a resident for the past 30 days. The board is allowed to conduct an investigation after the election to determine if a person is a qualified voter. And the commissioner has ordered districts to conduct such investigations in a couple cases in the past, and to seek penalties if so warranted. If an election results appear to have been affected by votes cast that have been by unqualified persons, the Commissioner does have the ability to annul the results and order a new election. It's not often that would happen because it requires a high level of proof, but that ability is there for the Commissioner of Education. Missing registration. If a person's name is not on the list of registered voters, they're not going to be allowed to vote unless they go through several steps. Either they present a court order mandating that they be allowed to vote, or they submit an affidavit with the following elements: that they are duly registered to vote, the address at which they are registered, that their poll record has been lost or misplaced, and they understand that all statement as to any of these matters is perjury. So a person will be permitted to vote by what is called an affidavit ballot. If they sign this affidavit, they vote by paper ballot, and it's on an envelope upon which the affidavit is written and is sealed until the canvassing of the ballot. Similar to it'll be canvassed along with, say, your absentee ballot. Voting in districts without personal registration. There are a large number of school districts throughout the state that do not require personal registration. So the district can adopt rules to require voters to provide a form of proof of residency when they present themselves at the polls, including either a driver's license or non-driver identification card, some sort of utility bill, or voter registration card. We can additionally require the voters to provide their signature, printed name, and address in school districts without personal registration. This is a way to ensure that those who are appearing at the polls are in fact residents of the district and entitled to vote. Absentee ballots. They have to be made available anytime we have an election of school board members, school district public libraries for our annual budget vote, school district public library budget votes, and any referenda or special meeting that the school district may have. Absentee ballots will be provided to any voter who cannot vote in person due to illness, physical disability, hospitalization, incarceration, unless they're incarcerated for a felony, or travel outside the area for business, studies, or vacation. As I said before, dual home ownership doesn't entitle you to come in person to vote at the elections. It also doesn't entitle you to vote by absentee ballot. You only have one legal permanent residence. You can't be a permanent resident in two states or two places at the same time. The education law does not include any kind of specific deadline as to when we have to have applications for absentee ballots available, but it's a good idea to have the applications available as soon as you publish that notice of annual meeting that includes the information about the absentee ballots. But you can distribute the applications earlier than the first time of publication of your notice of annual meeting if someone were to request it before then. Board of Elections under education law and election law, this is a little overlap here, has to send inspectors to nursing homes to supervise if there are 25 or more absentee ballots requested from the home. That was put into place 6-7 years ago now, I want to say. So applications for absentee ballots. A person can request more than one application. They're not required to say for whom the applications are being requested. Some people get very scared about everything, all the information that they need to record, but you don't have to record who you give applications to. That is not required by the law. District clerks are required to automatically mail absentee ballots to each voter whose registration record is marked as permanently disabled. They are not required to send an application. I've gotten some questions from district clerks this year where they have been told by the county Board of Elections that they have to automatically mail ballots to military as well. That is a provision within the federal law for general elections. It does not apply to school district elections as far as I can tell. If your district has been Given that information, I would say double check that with your school attorney and act under their advice. But I don't believe that that applies for school district elections. So applying for the absentee ballot, the information that must be included on the absentee ballot application is set by statute, and it has to contain the person's name, address, that the person is in fact a qualified voter, if they're registered in the district, the reason that the voter is going to be unable to appear in person on the day of the vote. Now, if the reason they're going to be absent is due to business or studies, they have to give a description of the duties and the nature of their business that ordinarily requires their absence. If it's not in the normal course of business or studies, they have to tell you what the reason for their absence will be. If they're going to be gone due to a vacation, they have to give the dates and the location of said vacation, and if they're self-employed or retired, a statement to that effect. If they are requesting an absentee ballot due to confinement, they have to tell us whether they're being detained while awaiting action or a grand jury, or if it's after conviction for a crime that is other than a felony, because of course the felony would take away their ability to vote if they were convicted. So the application has to be received at least 7 days before the election if it's to be mailed to the voter, or the day before the election if it is to be issued in person. Issuing the absentee ballot, upon receipt of the application, if you have a board of registration, they would review it, or if not, the district clerk reviews it and determines if the person is entitled to vote by absentee ballot. If they're entitled to the absentee ballot, it is then mailed or issued in person, and the voter's name is recorded on the list of voters who have been issued absentee ballots. Absentee ballots in districts without personal registration. A qualified voter may request an absentee ballot by a signed letter rather than by application in districts that do not have personal registration. The letter has to be received between 30 and 7 days before the election. Upon receipt, the clerk then sends both an application and ballot to the voter at the same time, and the voter has to return both in order for the ballot to be counted. So the application and ballot both need to be returned to the same envelope in order to get that ballot counted. Absentee ballots, the ballot must be received by the district clerk by 5 p.m. on the day of the election in order to be counted. The Board of Registration or the district clerk must make the list of all persons issued absentee ballots and have it available for public inspection during regular office hours of the district clerk. This again will facilitate any challenges that may occur to an absentee ballot. So any qualified voter can, prior to the election, file a written challenge to a person who appears on the list of absentee voters. You cannot wait until after the election to challenge an absentee voter because, again, you can't challenge someone after their vote has already been counted. In districts with personal registration, we cannot open and count the ballot before the polls close because challenges can occur during the canvassing of the ballot. So in districts with personal registration, how this happens is the election inspectors will examine the ballot, compare the signature on the ballot with the signature in the registration book, and they will reject the ballot if the name, address, and signature are not on the register or if there is not a signature with the ballot. During this examination period, while it is happening, any qualified voter can challenge the ballot because they feel that either the person is not a qualified voter or the person was located within the district when the polls were open, unless, of course, the person was hospitalized, in jail, or disabled. Inspectors have, in fact, a duty to challenge the absentee ballot if they possess any of that above knowledge that would disqualify the person's absentee ballot, and they're required to resolve all of these challenges. Inspectors do this by taking a vote. So candidates and or poll watchers are not required to be present during the canvass, but they certainly have the ability to be present. Preventing a qualified voter from exercising the right to challenge an absentee ballot can in fact be grounds for invalidating election results. To make sure that when you are counting the absentee ballots, if you have personal registration, that you make sure that people have the ability to challenge if so desired. So the logistics of the annual meeting and elections. In general, education law governs school district meetings and elections, not election law. There's sometimes confusion with respect to that. A lot of the confusion that erupted in the past few years has been over voting machines, because we now require, the use of these optical scan voting machines in our general elections due to the Federal Help America Vote Act. The state has acted to allow school districts to continue to use the traditional lever voting machines through December 31st of this year. The law, when it was passed, said that the Board of Elections has no obligation to maintain the care, custody, or control of lever machines. I know many school districts I've talked to across the state were able to purchase the old lever machines from the county boards of elections for very little to no money in some cases. However, this, is going to be expiring. But we do have bills in both houses of our state legislature addressing extensions on the use of lever voting machines. S6296 and its companion A9178 call for a permanent extension for the use of lever voting machines in school district elections and other small municipal elections. I know that here at NYSBA, New York State School Boards Association, we have joined together with a coalition of other small government agencies to advocate for this extension. The S6296 did pass the Senate and was delivered to the Assembly back in February. The Assembly has not yet taken action on it, at least as of a couple days ago when I double-checked it. A9134 is a extension as well, but it would only allow for extension of the use of lever voting machines for a period of 3 years. So we'll have to see what happens. The Assembly bill that allows for 3 years is kind of taking into consideration some of the issues. While many districts were able to purchase cheaply or take for free these old lever machines, we need to consider such issues such as what parts will be available if one breaks down. Are there people that are going to be trained to be able to fix the machines if they were to break or jam or something? Paper rolls for the machines have been an issue. I know I've talked to some district clerks. And this technology ultimately is becoming obsolete. So will there be a mandate at some point in time for school districts to use these optical scan voting machines? I can't say. But given that this is the trend of the industry, we have to be prepared at some point that we may have to face that. Obviously, the purchase of such machines, they are extremely expensive, and it would be devastating on our budget. So we're going to have to see what will happen with that in the future. But we are quite confident that there will be an extension of some kind that is passed by the legislature before the end of this session. Polling locations. We must have adequate access and parking for the disabled during the times that the polls are open. A violation occurred where during dismissal time, a school driveway was closed to traffic except school buses, and the parking lot was closed for construction. The Commissioner of Education, when that was brought to his attention in an appeal, so that was improper. Election districts. School districts have the ability to be divided into election districts and have multiple polling places if they have a system of personal registration. So union-free school districts and central school districts can create election districts either through a resolution of the Board of Education or a majority vote of the qualified voters at a district meeting. Once you decide to create election districts, the school board has to pretty much immediately adopt a resolution dividing the district into election districts. The resolution must be adopted at least 30 days prior to an annual or special meeting. Each election district under the law is supposed to have at least 300 qualified voters, and if possible, a school building in order to host the polling place. Small city school districts, boards of education can pass a resolution modifying the election districts that are already in existence. This is because, of course, small city school districts were fiscally dependent for a much longer period of time. and when they were made fiscally independent, the law allowed for the general election districts within the city school districts to be used as election districts for the school district elections. A city school district that has less than 10,000 inhabitants may designate the entire as a single election district. This is similar to other election districts. They should have a public school building where the voting is taking place. Obviously, if you are going down to a single election district, you should have one school building within the district that is appropriate as a polling place. The commissioner does, in fact, take this requirement by law that the city has to have less than 10,000 inhabitants. Previously, the city of Lackawanna, in appeal before the commissioner last year, had adopted a resolution modifying their election districts such that they had only one election district. They were challenged by a voter who said the population of the city of Lackawanna is greater than 10,000. And upon reviewing all of the evidence that was submitted, the Commissioner of Education agreed with the petitioner and ordered the school district to reinstate the multiple election districts. Voting booths have to be used in districts other than common school districts. This is, of course, because, as I said before, common school districts could still take a vote by a meeting of the entire district and people raising their hands. Ballots must be used if use of a voting machine is deemed to comply with voting by ballot under the law. If we use voting machines, inspectors are, of course, required to check that the counters are set at 0 and the ballot labels are properly placed. That is a very serious duty. We have some cases we're going to go over in the challenge to elections section where the ballots were not properly placed within the voting machine. In fact, did not display proper information, and that resulted in overturning election results. We have to ensure that the ballot contains the names of candidates that in the order that was determined by the drawing of lots that is conducted after the day the nominating petitions are due. If we use voting machines, there needs to be a slot for write-in candidates, and it has to be provided in every situation. So if we vote for school board members by specific seats, we need one blank under each seat. If we vote for our school board members at large, then we must provide blank slots equal to the number of vacancies to be filled. So if you have 3 seats up for election, there needs to be 3 slots for write-in so that people can choose 3 different write-in candidates as opposed to the nominated candidate. There's no authority for proxy votes under the education law, and all voters present in a polling place at the time the polls close must be allowed to vote. So you can shut the doors and not allow other people to come in, but you have to allow those who are present at the polling place at the time the poll closes to finish their business and vote. Poll list. The district clerk has to maintain a poll list with names and addresses of those who actually vote. So people have to sign the poll list. It has to, the poll list is a public document that's available for inspection and copying. On the day of the election, we have to take special care to provide access to the poll list in an even-handed manner and one that is minimally disruptive to the electoral process. We do not have to provide access to the poll list if it's somehow going to disrupt our election process. Poll watchers. In school districts with personal registration, candidates have the ability to designate poll watchers. Poll watchers, just like in a general election, cannot interfere with the election, engage in electioneering. They're just there to observe the process and make sure that no laws are being violated. In districts without personal registration, there is not a specific requirement in the education law that allows for poll watchers, but there's nothing that would prevent a qualified voter who supports a particular candidate from observing the proceedings and challenging voters, and you don't even have to want to support a particular candidate. If you just want to make sure that people who are presenting themselves to vote are in fact qualified voters, and you have the time, you can sit there at the polling place and challenge voters, provided you don't disrupt the electoral process. So if someone is engaging in disruptive behavior, you would be able, of course, to ask them to leave. So election inspectors. Non-city school districts, we have to have 2 elections inspectors per ballot box or voting machine. Common school districts, inspectors are elected by the voters. Union-free and central school districts, the board appoints the inspectors and designates a chief inspector. If the district has chosen to be divided into election districts because they have a system of personal registration, then you have to designate a chief inspector for each individual election district. City school districts, there's going to be 3 election inspectors per election district as a minimum, but the board has the ability to appoint additional inspectors as deemed necessary. The inspectors elect among themselves a chairperson in each district in this case, and then the chairperson has the ability to appoint an inspector as an assistant poll clerk. The failure to appoint the required number of election inspectors can result in invalidation of an election only if the error somehow affects the outcome of the election. The same is true if the district removes 1 inspector on the day of the election. So say that there is a problem with an election inspector on the day of the election and that person has to be removed from duty. That is not going to result in an invalidation of your election results unless somehow it is proved that that election inspector tampered with results in some way, that you cannot be assured of that. So the technical inability to comply with the correct number of election inspectors for a period of time is not going to result in an invalidation of your results. Small city school districts, election inspectors must be qualified voters, so they have to be residents of the district. An amendment in 2010 to the education law permits the appointment of 17-year-old students enrolled in the district to serve as an election inspector with parental consent. Students serving as inspectors while school is in session are recorded as in attendance that day at school. The law does specifically provide for that. And the failure to appoint a student as an inspector is not going to be cause for invalidating an election. When we were going around the state doing our district clerk forums, we learned from several districts that they were in fact taking advantage of this law and using 17-year-old students from their student council to serve as election inspectors. And the way that they were thanking them and paying them was by providing them a certain voucher of meals in the school cafeteria. So that's a unique way that you guys can maybe potentially approach having different election inspectors. In some districts you may have difficulty in recruiting new inspectors if your inspectors have aged out. So this is certainly a new way to recruit some inspectors. District employees, board members, and relatives of board members or candidates can in fact serve as election inspectors. Obviously, you know, that they can serve as election inspectors, candidates, etc. That may not be the best idea. You can, of course, discuss that with your individual school district council to determine if that would, in fact, be a route that you wanted to go. In union-free and central school districts, the Board of Education sets the rate of compensation for the inspectors. In the city school district, the board sets the rate, but it cannot set a rate that exceeds the compensation that was paid to election inspectors at the preceding general election as fixed by the body that governed those inspectors. Election inspectors and assistant clerks appointed by the Board of Education will be entitled to some kind of compensation. Since common school districts the election inspectors are not appointed by the Board of Education, that is why they are not entitled to pay, because they're elected by the voters there at the meeting. Just a little weird snafu in the law. Counting ballots. We count ballots to determine if we agree with the number of names that are recorded on the poll list. If it exceeds that number, then the chief inspector will withdraw at random ballots to reduce it to be equal to the number of voters. Inspectors will then count the remaining ballots. When we're counting absentee ballots, we have to ensure that the person did not vote in person. Examine, as I said, the envelope, and if there is no signature on the outside of the envelope, it will be set aside and not counted. If an absentee ballot has an incorrect date on it for some reason, it It is not unlawful to count it simply because it has an incorrect date. Missing or inaccurate dates on ballot envelopes, the Commissioner of Education has said, are not grounds for voiding that ballot. The chairperson of the meeting declares the results as announced by the election inspectors. So counting the ballots, election districts, and voting machines, the inspectors make a written report of results to the chief inspector of each district, who then reports it to the clerk within 24 hours. The school board tabulates and declares the results within 24 hours of receiving the results. I know typically most districts carry that all out within the evening of the election after the close of the polls. Voter approval of the proposed budget. A simple majority of those voting are needed to approve a school budget within the tax levy limitation. If a proposed budget requires a tax levy that exceeds the levy limitation, then 60% of those present and voting must approve the budget in order for it to be adopted. As I alluded to earlier, voter approval requirements when you have multiple propositions, so you may have a main budget proposition and supplementary expenditures and additional propositions. If that additional proposition is for additional transportation service and the level of expenditure when you combine those two propositions, the main budget and the additional transportation, exceeds the tax levy limit, then 60% or more is required in order to approve it. Same goes for if you have a proposition for educational programs that's separate from a core budget proposition. So if you separate out a specific educational program that is not typically required by the state, but you have chosen to offer in the past, it will require 60% approval if that expenditure will take you over the cap. If the proposition is for a capital expenditure or a transportation capital expenditure, then all that is required is a simple majority, because those are the two exceptions to the exceptions for the school district property tax levy limit. Okay, so approving the budget. The school board can submit a budget or any proposition involving the expenditure of money for a vote at a district meeting no more than 2 times, and this includes the revote of the budget. Exceptions are going to be dealing with proposition for construction of schools. It cannot be submitted more than twice during any 12-month period. And moreover, the second such proposition, if the first is defeated, cannot be submitted to the voters within 90 days of the first vote. However, neither of these limitations is going to apply where the voters approve a building project, but the bids that are subsequently received by the school district on the project exceed the amount originally approved by the voters. You are then allowed to go back to the voters to seek additional funding. Voter rejection of the proposed budget. School district, as you well know, has a couple options. They can prepare and adopt a contingency budget without going back to the voters, subject to caps on contingency budgets. Given the tax levy limitation law to the changes that we have a 0% cap on contingency budget, this is obviously not an attractive option. Or we can present the original budget for a second vote, or a revised budget for a second vote, or for a vote at the uniform school budget revote day. Or we could choose to adopt a contingency budget and present one or more propositions to the voters, giving them the opportunity to vote to fund services that are not able to be provided without voter approval. As you guys are well familiar, ordinary contingent expenses are the only things that can be funded on a contingency budget. This has not been changed by the property tax cap law. So we could choose to say, present a budget that was well under the 0% cap somehow, and then have additional propositions for things that are not ordinary contingent expenses that will still keep us under the 0% cap. A separate proposition can be presented for each service, or such services can be combined and included in one proposition. Nothing prohibits the school district from combining several unrelated objects and purposes into a single proposition. It's really going to be up to the Board of Education to decide if they really want something to pass and be adopted by the voters, and they know that there is no support for an additional item that would be included within the proposition, then you may want to have a separate proposition. But it is okay to link items in one proposition, but you run the risk of it potentially being voted down. A school board is under no obligation to submit a budget to the voters more than once. Once you submit that on the third Tuesday in May, you're not required to go to a budget revote. You do have the ability as a Board of Education to adopt a contingency budget without putting up a second budget for a vote. That is within the discretion of the Board of Education. The date and time of a budget revote. So if the school district chooses to hold a revote, it must be held on the third Tuesday in June. This is the statewide day for holding school district budget revotes. Again, that 2-vote limitation is going to apply in this situation. So improper advocacy. Legal restrictions on promoting the budget have been in place since the New York State Court of Appeals handed down the Phillips versus Maurer decision, which basically says we cannot use district resources or personnel to urge voters to approve the budget or any other proposition that we've put up there. We can distribute purely factual information, so pamphlets explaining a bond issue have been deemed okay. Because according to the Commissioner of Education, we have an obligation to present and publicize the budget so as to promote public comprehension of what they are voting on. But it's not just about urging a yes vote. Even statements which persuade or convey support for a particular proposition are improper. And the Commissioner of Education has said he can and will hold school districts accountable for actions which create an appearance of impropriety. And he will annul election results if he feels it is warranted. For example, you should not use district phones to call selective lists of voters and urge them to vote. That creates an appearance of impropriety. So say the list you were using was only for people who had children enrolled in the schools. Obviously, those are the people who are going to come out and support your budget. So if you want to call people and urge them to vote, make sure they vote. That doesn't mean urging them to vote yes, just get out the vote. Sure, you can do so, but don't use a selective list. Use a list of all voters in the district. The Commissioner has also frowned upon the use of rewards to parents for voting. In one school, they gave out a coupon. They sent it home in the school children's backpacks that the parent could exchange at the polls for a book or toy for the child. The Commissioner said that created an appearance of impropriety. Advocacy by individual board members and other school officials. Certainly, in your personal capacity, you can actively support a proposed budget. You don't lose your First Amendment rights to free speech simply because you sit on a Board of Education or are employed by a school district, but you have to ensure that your advocacy is at your own expense, and you have to avoid giving the impression that you're speaking on behalf of the board or district. Just because you want to write a letter to the editor, you can do so, but you have to clearly distinguish your views as your own, because even though you may not say, hey, I sit on the Board of Education or I work in this school district, oftentimes if you're, a superintendent, a school board member, what have you, if you write that letter and you don't identify yourself, the editorial board at the newspaper is going to slap a label underneath your name describing you as a board member, a superintendent, an employee, what have you. So the Commissioner of Education has said that you have to be very careful to express that your views are your personal views within the body of any letter, even if you don't identify yourself by your specific title. We have to ensure that teachers and staff do not communicate partisan positions to students on school time. Staff can also be prohibited from wearing political buttons in the classroom. The Commissioner of Education has said political partisanship is inconsistent with our educational mission. That was a case that arose out of, actually there was a court case that arose out of New York City during the last presidential election where teachers that were members of the teachers union in New York City wanted to wear pro-Obama buttons. The court said that political partisanship is not appropriate, that children need to be free from that and concentrating on learning in the classroom. But the Commissioner of Education in a different case that came before him said that There was nothing improper with a teacher explaining to students the meaning of contingency budget after a budget had been voted down in that district, because he only provided a factual explanation. We also have a responsibility under Phillips v. Maurer to make sure that our district facilities or channels of communication are not used by third parties to engage in promotional activities. So the PTA should not send home flyers urging passing of the budget in student backpacks if you have a student backpack program. Also, unions cannot use mailboxes or email to promote candidates' support for a Board of Education, even if the collective bargaining agreement grants them the authority to use school district physical mailboxes or email to for union business. The Commissioner of Education has said that it is improper to allow them to use their access to advocate for a particular position or candidate. So the election of school board members. Qualifications of school board members. Oops, what happened here? Okay, there we go. Whoops, we skipped a slide. Go back. Okay. We have to have, a candidate has to have the ability to read and write, be a qualified voter of the district, a citizen of the U.S., at least age 18. They cannot be incompetent, and that means not the legal standard for mental incompetence. A resident of the district for at least a period of 1 year immediately preceding the election. They cannot have been removed from any district office in the preceding year. They cannot reside with another board member of the same family. So you will never see a husband and wife on a Board of Education at the same time, but you could potentially see adult siblings, a brother and sister, serving on a board at the same time, provided they do not reside in the same household. A person cannot be a current employee of a district and serve simultaneously on the Board of Education, and they cannot simultaneously hold an incompatible public office. We'll talk about that more in a minute. The U.S. Supreme Court has said it is unconstitutional to ban members of the clergy from running for office, so reverends and others can run for office. The school board cannot impose any kind of additional eligibility requirements for board office, and a former employee of a school district has the ability to serve on the school board. The former employee, the law provides, does not have an issue if they vote on matters which may pertain to their own personal interests, such as retiree benefits. Contracts of unions are not deemed to conflict with that. That is permissible under the law. There is no prohibition against the employment of spouses, children, or other relatives of candidates or board members by the district. The general municipal law specifically says that a contract of employment, there is a statutory exemption from that for a conflict of interest. So a board member may have a spouse who is employed by the district, and that is not a prohibited conflict of interest. We account for that in certain other situations by requiring 2/3 board approval to employ or grant tenure to a teacher who is related to a board member by blood or marriage. Incompatibility of office. So basically what this involves is that a person cannot hold two public offices or positions of employment if one is subordinate to the other or the positions are inherently inconsistent. By being inherently inconsistent, well, you can't be both an auditor and a treasurer in the school district. And you can't be your own boss, basically. So 2 questions to evaluate if dual office holding will be permissible. Whether there's an express prohibition against the board member holding or running for the office in question, or whether the duties of the two offices may in fact be legally incompatible. A person may generally be a candidate for election to a second office if that is incompatible with the first office that they hold, if they plan to resign from the first office if elected. However, if it's incompatible by law, such provision can in fact disqualify a person from being a candidate for the second office. We had an issue before the Commissioner of Education not all that long ago with respect to this because someone who was a candidate for a school district in a small city school district served on the city's Board of Elections, and the election law provides that a city election commissioner cannot hold any other city office. And basically, the Commissioner of Education, in looking at this, determined that the person could not be a candidate for the election. And we do talk about that in the outline. It's in my material. Once elected, upon accepting a second office, if the person holds an incompatible office prior, they vacate that first office automatically upon taking their oath of office for the second office. The education law prohibits a board member from simultaneously holding a number of positions. They can't be a BOCES district superintendent and serve on the BOCES board, obviously. They cannot be a superintendent of schools and serve on the Board of Education, where they are the superintendent. A supervisor, a clerk, tax collector, treasurer, librarian, or employee of his or her school board. There is a small an exception in union-free and central school districts where a board member may be appointed district clerk. And all this is laid out in more detail in my outline. Other positions that have been deemed incompatible by the Attorney General, some examples, board member of a private school in the district. As I said before, the County Elections Commissioner in any city school district. In the outline, there is a greater listing of positions that have been deemed compatible with school board as well. So you can be a trustee of a public library, a town assessor, a member of a town zoning board of appeals. These are compatible with school board service. Part-time judges, full-time judges may not seek election to a local school board or retain a seat on the school board after elected to the judgeship due to the quasi-political nature of board membership. What the Commission on Judicial Ethics in New York State has said is that Board of Education members deal with highly controversial issues which are incompatible with holding judicial office. So that is going to prevent a judge from serving on a Board of Education. Nominations. We have two types of nominations, either specific seat or at-large voting. Generally, nominating petitions in the majority of school districts are for specific seats. However, voters may adopt a proposition to make each nominee eligible for every vacancy, i.e. at-large voting. In small city school districts, the default is that board members run at-large unless the voters adopt a proposition for a specific seat. If the voters adopt a proposition to become at-large, if they have specific seats, it doesn't become effective until the next election, and then it's going to remain valid until repealed by the voters. Nominating petitions under the law are required signed by at least 25 qualified voters, or 2% of the number of voters in the previous annual election, whichever is greater. Small cities, they need 100 signatures. A person does not have to be a registered voter to be considered a qualified voter, so someone who is a qualified voter but who may not be registered with the district has the ability to sign propositions or petitions. There is no limit on the number of petitions that a voter may sign, so if they want to sign everybody's petition, they can. Nominating petitions have to include the candidate's name, residence, and the residences of the voters who sign the petition. If the school district runs for specific seats, it has to identify the seat for which the candidate is running, so it has to include the name of the incumbent and the length of the term. There's no time specifically named in law for the commencement of collecting signatures on petitions, so candidates have the ability to do that. It's impermissible to impose greater requirements on nominating petitions other than that specified by law. So the Commissioner of Education invalidated the school district's policy that required the candidate to verify their petitions by swearing to it before a notary. The Commissioner of Education said that the school district did not have the ability to impose that greater requirement of having it notarized. The deadline, 5 p.m., 30 days before the election, the petition has to be in. In small city school districts, it's 5 p.m., 20 days before the election. Notice of the deadline has to be included in the notice of annual meeting. We went over that previously. Acceptance of petitions. We're going to reject a petition if it's somehow improperly filed, if the candidate is ineligible for office, or if the person's unwilling to serve. The school board determines if the board candidate is eligible to serve. The petition should not be rejected if a candidate's name, address, and specific seat are not included on every page of the petition, and the person did not know who were signing it, did not know what they were in fact signing. The Commissioner of Education has said in an appeal. Write-in candidates, all ballots, as I said before, have to have at least one blank space for each vacancy on the board. When you write in a name, you do not need to place a check mark next to the name that you have written on the ballot. Minor misspellings should be credited to a candidate unless another resident has the same or similar name. In one case from, I believe it was 1980, the Reverend Frederick R. Jordan mounted a write-in campaign, and people wrote his name in about 15 different variations. The Commissioner of Education said all of those should be credited to him, even if there were minor misspellings, or some people included Reverend, others did not. So that's just an example for you. If there are no candidates or not enough candidates, seats are going to be filled by the individuals with the most write-in votes. So that is an issue that does, in fact, emerge from time to time in school districts. I was talking to a district clerk yesterday who did not have enough candidates for the number of seats that were up for election. Candidate withdrawal, death, or ineligibility. So if a candidate withdraws, dies, or somehow becomes ineligible at a point in time later than 15 days before the last day for filing petitions, the district is going to be required to extend the nominating deadline by as many as 15 days. Petitions cannot be filed later than 5 p.m. on the 7th day before the election. So a candidate who withdraws their petition, if they decide to resubmit their candidacy, they have to file a new petition within the same time limitations that are applicable to all candidates. Examples, say this year, Union Free and Central School District petitions were due on April 18th. So to extend the deadline, someone would have to withdraw after April 3rd, 15 days before the deadline. But we cannot extend the deadline past May 10th, 7 days before the election. I think that my example is from last year, so if you're confused by the dates there, I apologize. Ballot. The district clerk is going to conduct a drawing of lots to determine the ballot position the day after the deadline for filing petitions. So the clerk will notify the candidates that the day after the nominating period closes, they have the ability to come to her office and draw lots to determine their position on the ballot. If they cannot attend, the law authorizes the district clerk to act as their proxy. Or they could send a proxy of their own designation if they so chose. For specific seats on the ballot, at the top of each group of candidates, we need to have a description of the length of term and the name of the last incumbent, and a direction that only one vote may be cast in each separate group. So those are the ways, that is the way that we have to set up our ballots in the machine. But an appeal from a losing candidate who failed to prove that she lost the election because the district's printer mistakenly printed the candidate's name in the wrong order was dismissed by the Commissioner of Education. That was not enough to prove that the election was conducted in a improper manner. Campaign expenditure and contribution statements, they're required when expenditures of a candidate exceed $500. The sworn statement will be filed with the clerk and the commissioner itemizing expenditures and contributions received. Expenditures made without candidate approval are limited to $25. They're not included in the statement because they're made without the candidate's approval. The statement has to list the amount of money and other valuable things paid, given, expended, or promised by the candidate, incurred for or on the candidate's behalf with his or her approval. Those who are making unapproved expenditures have to file a sworn statement with the clerk and the commissioner that the candidate, in fact, did not approve this expenditure. If someone spends less than $500, then they simply file a statement with the district clerk to that effect. Contribution statements have to include that dollar amount of any donation or the fair market value of a contribution other than money. the name and address of the donor. There are special rules if a donor is a political committee. Political committee is defined in the election law. It's any entity dedicated to the aid or defeat of a particular party, principal, or candidate. There are special rules that apply to their donation. As I said, a candidate who spends $500 or less simply files that sworn statement with the district clerk that this is the case. The statements are required to be filed at 3 intervals. An initial statement at least 30 days before the election, so when they turn in their petition, apparently they also need to turn in their initial statement. At that point, it's probably going to be, I've expended no money, or I've expended less than $500. A second statement on or before the 5th day before the election, and a final one within 20 days after the election. Every statement must cover the period up to and including the day of filing. Any contribution in excess of $1,000 received after the close of a reporting period is required to be reported within 24 hours. Failure to file statements, the school district has to notify the candidate, who would then hopefully promptly file. However, if they do not, there is nothing that the school district can really do about this. Any other candidate for office or any 5 qualified voters are empowered by the law to commence a legal action to enforce the law if the candidate fails to file these expenditure statements. But the Board of Education itself is not empowered to begin such litigation. The failure to submit a complete statement is not grounds for setting aside election results. On the day of the election, we are going to be dealing with electioneering issues. So there is a prohibition against electioneering. The distribution of materials in support of or opposition to any particular position is not allowed within 100 feet of the entrance to a polling place. That would constitute impermissible electioneering. So the district election inspectors have to post distance markers delineating the zone. However, the distribution of purely factual information at polling places is permissible. Declaration of the winner. You're elected by a plurality of votes for each vacancy. If there is some reason a tie vote, a runoff election is going to be held. At-large districts, if there are vacancies of differing lengths, positions are filled in decreasing order of number of votes and length of office. So if a seat expires at the end of the year and the seat is vacant, the person elected to fill the full-term vacancy is entitled to fill the portion of the term preceding the commencement of the full term, i.e. it goes to the highest vote getter. District clerk has to notify every person in writing who is elected as a school board member, and must also report the names and addresses of winners to the town clerk in the town where the district is situated. That is a provision of the town law that overlaps with us. Taking office, you have to take your oath of office within 30 days. If you do not take of the commencement of your term, so if your term commences July 1st, it has to be within 30 days of that date. Otherwise, the seat will be deemed vacant for failure to take the oath of office. You're deemed to accept the office that you've been elected to unless you file a written refusal within 5 days after you're notified of your election. Challenges to elections, we'll try and cover this really quickly in the last couple minutes we have left. Appeals to the Commissioner of Education. The process must be utilized by both community members who challenge the vote results and if a Board of Education itself. The Commissioner can order a recount or a new election. Pretty much there's a presumption of regularity in the conduct of elections. The burden of proof rests with the challenger, who has to show that the district engaged in improper conduct and that improper activity actually affected the outcome of the election. The Commissioner of Education has also said that he will overturn results if a challenger can prove irregularities occurred that were so pervasive that they vitiated the electoral process, or they demonstrated clear and convincing picture of informality to the point of laxity in adherence to the education law. And that is actual language that the Commissioner continually quotes. It's rare for errors to be so pervasive that they vitiate the electoral process, but it is not impossible. It has, in fact, happened. The Commissioner of Education also sometimes looks at a probability standard to use to overturn results. For example, he set aside the results of an election where approximately 30% of the votes were cast using a lever either directly above the first candidate's name or to the side of the last candidate's name. So 30% of the voters voted for no one, essentially. So the commissioner said we could not determine the will of the voters in that situation. If a board member's election to office is overturned, the Commissioner of Education has determined that the person initially declared the winner is a de facto member of the Board of Education during the period of the appeal, and any actions taken by a board during that time are in fact valid. Boards do not have to worry about any resolutions they voted upon with that other board member are invalid. Typically overturning election results. Deficiencies in an election notice are not usually grounds for overturning election results unless somehow the actions were willful and fraudulent. Technical failures will not result in a commissioner overturning elections. So if a newspaper incorrectly prints the date of your budget hearing, but you as a school district show that all of their information had the correct date for the budget hearing, there was nothing willful or fraudulent, it was the newspaper's mistake, you're not going to have your election results overturned. Discrepancies between machine counts and poll lists do not necessarily require the commissioner to invalidate election results. There must be evidence that the outcome was affected by this apparent failure of some voters to sign in at the poll list. So we'll have to see in this sort of a case-by-case basis. A few cases I want to go over very quickly where the Board of Education itself filed a challenge. Appeal of the Board of Ed of Beekman Town. The board petitioned the commissioner due to an error in their ballot display. They had 383 voters use a machine which incorrectly displayed the 2010-2011 budget and bus propositions instead of the 2011-2012. The Commissioner of Education said, and their budget only passed by 16 votes, that due to this error, the voters were deprived of using a voting machine, deprived of essential information that they needed to cast their votes, and therefore the will of the voters could not be determined. And he overturned the district results and ordered the district to call a special meeting to hold a revote on the budget proposition. In appeal of the Board of Ed of Crown Point, the board sought an order seeking to annul and correct the canvass of votes for the 2011 budget after they discovered that the total number of votes cast on the budget, 270, did not match the sum of the results certified by the election inspectors, which was 229. In that case, there were 138 yes votes, 86 no votes, 4 abstentions, and 1 void. The information before the commissioner showed that an examination of the tally sheets showed 41 yes votes were allegedly not included in the final count. The commissioner looked at these tally sheets and said the markings were unclear, and he ordered them to conduct a recounting of the ballots. The Board of Ed in deposit sought to annul the certification of the election results for the 2010 budget vote. The election inspectors certified the vote as a tie after several counts, but determined to recount in the morning, as they noted a discrepancy between the total number of votes cast and the total number of voters on the poll list. This was the first time that this district was using paper ballots, so there was a discrepancy. There were 447 votes cast and 449 total voters. They conducted a recount on their own the next morning, and the budget passed by 1 vote. However, and they solved this discrepancy by discovering that 2 ballots which had lacked a vote on the budget had been inadvertently discarded in garbage cans in the auditorium. The recount was upheld by the Commissioner of Education, but he cautioned the district to comply with the law in the future because boards of education cannot simply determine on their own to conduct a recount. They have to ask the commissioner to order a recount. He also cautioned them to comply with the provisions of law that you have to save ballots and have them locked in the ballot box until 6 months after the election, and then you can destroy them provided there's no challenge to the election that has been filed. So we're slightly over our time here. I don't know if there are any questions, but I'm happy to stay on the line and answer some if there are.
Okay, great. Thanks, Kim. If anyone has any questions for Kim, please hit the number 7 key and the pound key on your phone. They'll notify me that you have a question, and they'll put you right through. We'll give you a couple seconds. Go ahead and do that. Okay, Kim, we have no questions. Thank you very much for presenting for us today.
You're very welcome. Again, if anyone has questions that they think of later in time, you have my contact information here, and I'm more than happy to talk to any of you.
Great, thank you very much. Have a great day now. Thank you everyone for attending.
The moderator has ended the